Yes, it's nice to see this.
My lords, my ladies, may it please the court, I'm going to address you today on two subjects. Perhaps before I begin, just on a point of housekeeping, Opus will be made available to the court. It's not quite available to you yet, but it should be by the time we reach the first morning break.
Well, that's very kind, but I'm not sure it helps now because we've been marking up the hard copies. So
I understand, and I'll give both references in case it is of any help, my lord, and you'll make your choice.
Thank you.
Thank you.
I'm going to begin, my lords, my lady, on the subject of why the appeal of the learned judge's judgment should fail on the merits of the appeal, before then turning to the application to admit fresh evidence. I'll deal with the issues in that order. But let me say some introductory words about the application to admit fresh evidence, by saying that having argued the point that is now before this court, before the learned judge, and having lost on the point, the appellant then took matters into its own hand and has solicited a supportive statement from the US government, as you know, that's notably almost verbatim its position before the English court. And that statement comes, of course, from a party that is itself a respondent state in other investor state arbitrations, and therefore we submit is not an independent non-litigant. Now, we refer to the US diplomatic note with respect as a rabbit out of a hat, and a belated one at that, an intervention offered to alter the respondent's rights as already determined by an English court. That is, we respectfully submit a self-interested intervention procured through opaque means and in a specific political context that is set out in our supplemental skeleton. And it's an intervention, my lords, my lady, that gives rise to a paradox in the appellant's position that became, with respect, increasingly apparent during my learned friend's submissions yesterday. Either the note simply reflects prior US practice and therefore adds little to this debate, and therefore could not be said to be likely to have an important impact on the result before the learned judge, and so doesn't pass the Ladder-Marshall test, or it introduces a novelty which makes it important, in which case, as we shall come to discuss, it falls foul of the critical date doctrine under international law, as well as the first limb of Ladder-Marshall, because there has been no case made to this court that it could not, with reasonable diligence, have been obtained before the learned judge. My lords, my lady, you asked my learned friend that question twice yesterday, I believe. I don't believe you got a clear answer to the question, could it have been obtained with reasonable diligence before the learned judge? You didn't get a clear answer, which we respectfully submit is an answer in and of itself. Now, that outcome of inadmissibility should not come as a surprise, because investment treaties create rights for third parties that they are entitled to rely on, acquired rights, in this case, rights that they prevailed on at first instance without a US government intervention. I'm going to return to admissibility, but ask you to keep that basic paradox in mind while we discuss the merits of this application for appeal. Now, the appellant's grounds of appeal contend that the judge committed three categories of error, as you know. These are summarized in paragraph 18 of my learned friend's appeals skeleton. And to situate ourselves, it may make sense for us to turn it up. It's at the core bundle, tab 3, page 21. This paragraph summarizes the structure of the appellant's arguments, which are then developed in subsections B, C, and D of my learned friend's skeleton. And as you've heard, those three alleged categories of errors are that the learned judge erred in his approach to treaty interpretation, so-called errors of approach. The second category is that applying that approach, the judge allegedly erred in his interpretation of the treaty, the core issue, we would respectfully submit. And the third category is that it is said that the learned judge departed from a well-established position set out in some other arbitral awards pertaining to a different treaty, the North American Free Trade Agreement. I shall endeavour to address each of those three categories in turn, and I shall do so by close reference to the learned judge's judgment, because we submit that the answers to the grounds of appeal appear in a judgment that is both carefully and compellingly reasoned. Now, as we turn to the allegations of error, I note first, my lords, my lady, that a general criticism was levelled at the door of the learned judge yesterday for his focus on the English case law on section 67 rather than on arbitral awards. We say that that criticism is entirely misplaced. The judge quite rightly had uppermost in his mind that this was an application under section 67 of the Act for a de novo review. And the scope of that review has given rise to understandable policy concerns that it should be kept within certain limits. A concern that has given rise to a rich case law, distinguishing between different types of objections that are or are not ones of substantive jurisdiction under the Act. A distinction that is not relevant, certainly not as relevant, to arbitral tribunals seated in other parts of the world deciding international investment treaty cases under other treaties. And as we shall see, that rich case law has led the English courts to recognize that that which is jurisdictional and that which is not necessarily drawn at the same place by arbitral tribunals, as it is by the English courts. And it also has led the English courts to conclude that issues that are heavily integrated to the merits of the dispute are less likely to be jurisdictional under the English Arbitration Act, because the English Arbitration Act provides for a de novo review. Let me offer one example up front that I shall come back to, but I hope illustrates the point. Let us suppose that a party argues that whether a measure has been adopted is a jurisdictional question. And let us suppose that the alleged measure in question is an illegal expropriation. We submit, my lords and my lady, that it cannot be the case that a party would need to demonstrate an expropriation has occurred, the heart of the merits of the dispute, in order to establish jurisdiction. But inversely, if there has been no expropriation, so the argument would go, so there is no jurisdiction. Now, that would be the consequence, as we'll come to explore, of the appellant's position. as to the better interpretation of the Chorus Free Trade Agreement.
Mr Foxton, what was said yesterday, and I'm not sure what you've said so far quite responds to this, is that both parties agree that this dispute turns on the proper interpretation of the treaty, and in particular whether Article 11.1 effectively qualifies 11.16/17. How does the English law principles to which you've just referred, how do they help? Given that what we were told yesterday was that it was common ground that if as a matter of treaty interpretation 11.1 did qualify those provisions, then it is accepted that that is jurisdictional for the purposes of the Arbitration Act.
My lady, we accept that, of course, we interpret the treaty first and foremost by reference to the Vienna Convention, and we'll come to that interpretation in due course. But superimposed on that is a consideration that the English courts arrive at in determining that proper interpretation as to how closely an issue that may have been called jurisdictional in the underlying arbitration is integrated to the merits. It may not be determinative of the question, and as we'll see, the learned judge didn't say that it would be determinative of the question, but it was relevant to the learned judge's interpretation, and quite properly so, of the investment treaty.
Well, I'm still struggling with that because the interpretation of the treaty needs to be in accordance with the Vienna Convention. It would be somewhat extraordinary if in principle, courts of different jurisdictions ought all to apply those principles. They're not qualified by reference to the domestic law of the state in which a particular court is located. So I'm still not sure I follow your point.
Yes, well, we should look at the way in which the English court has looked at this before, because the principle that I've just outlined is one that has been reflected, for example, and we'll come to this in the Dayani judgment.
These are all first instance decisions, aren't they?
They are, indeed. And so for you to consider, my lord.
I'm speaking for myself, and obviously please take us to them, but having looked at them, I'm not sure how much they really assist with the question of interpretation we need to address.
I understand that, my lady. I suppose, and perhaps I won't put it higher than this, one of the questions that the first instance court has asked itself before is what the implication of an interpretation of an issue under the English Act as substantively jurisdictional would be given the de novo review function under the Act. And that is not a question that arises to an arbitral tribunal, and that is one of the reasons why arbitral tribunals have used the terminology differently from the English courts. And that's one of the reasons why the English courts have had a certain distance in being guided by the terminology used by the underlying
That's
tribunal.
a different point.
Yes.
That's talking about the terminology used by the arbitral tribunal, whereas ultimately we've got to interpret the treaty.
Indeed. And I certainly don't disagree with that, my lady. I suppose the question of implication is one for you to consider. I don't think that I am misstating my learned friend's case when I say that if the measure in question is an expropriation, then on his argued for interpretation of the treaty, that would be a matter of jurisdiction open for de novo review. Now, if that's where the interpretation of the treaty leads you, then that's where the interpretation of the treaty leads you, I understand. But I would respectfully submit that that is an unlikely interpretation and not a necessary interpretation when we come to the language of the treaty.
Can I just follow up from my lady's point, which I have to say, with respect, I agree. Another way of looking at this is when we're talking about jurisdiction for the purposes of Section 67, it's quite plain, is it not, in these circumstances, that we are what is engaged is whether or not the offer to arbitrate encompasses the dispute in question. Yes. So what is the offer to arbitrate? You have to look at what the offer is in the treaty, and that is purely and simply interpretation of the treaty. And the English court cannot, it seems to me, have any domestic approach to whether or not how you construe that offer, because it must be a matter of international law reflected in the Vienna Convention. And for my part, I can't see any scope for saying, well, this is how, as a matter of applying Section 67, we approach the interpretation of an offer. Can it?
Well, it seems to me that, my lord, that at first instance, court after court has indeed asked itself that question. What would be the implication? Given that there is this superimposed question by English law, which is de novo review.
Yes. Well, but I don't think, take us to them, but I don't think those cases were interpreting the treaty, dealing with a disputed question of treaty interpretation, which is what we have. Apologies.
They were asking themselves, my lady, what the scope of the agreement to arbitrate
indeed,
is.
But that's a different question.
Yeah.
Well, one can certainly see that when you are considering whether or not you interpret a particular agree or offer to arbitrate, you can certainly take into account, as a matter of all the circumstances, that it would have very strange consequences, including that the arbitrators would have to determine their jurisdiction by determining the dispute. But it doesn't seem to me that's a matter of the English law of Section 67. It's an approach to interpretation.
It certainly is an approach to interpretation, my lord, but English courts have, at first instance, also considered it relevant to considering the
Yes, but I think one of the purposes
67.
of this case coming here is so that we can look at it.
Yes.
And we're not bound by those decisions, and if they've got it wrong, they've got it wrong.
Indeed. And I will point them out to you, and the court will take its view. But I would say that there is an oddity, and it is certainly relevant at the treaty interpretation stage. Ordinary terms, Article 31.1, in good faith, object and purpose, in context. The idea that you would need to demonstrate an expropriation in order to establish jurisdiction would be a treaty oddity. Now, we'll get to the terms, and of course I accept that the terms govern here, and that's what I'm going to spend most of my time talking about. What I've done here is introduced a view that the English courts have taken in analysing these questions, recognising that in Dayani there may not have been the same muscular debate about what dispute meant. Now let's look at some of those cases, and what I'll do, rather than take you to the cases themselves, my lords, my lady, unless you wish to, is offer you a review of those cases that the learned judge thought it appropriate to consider and set out in his judgment. You'll find them in his judgment, so that's Core Bundle tab 6, at paragraphs 24 to 36. That's Opus reference 80 onwards. Now that case law was particularly well known to the learned judge, of course. We respectfully submit that he has reflected it faithfully. There has been no suggestion otherwise from the appellant. As I said, I don't propose to go through the case law in detail, but I will draw attention to some of the points that we just discussed. The judge began his review by referring to his decision in Diag Human, which is, of course, another judgment that is before this court presently. But in relation to Diag Human, let's look at what he said in paragraph 28 of the judgment in this case. And I'd invite you to pick it up from the second sentence. the sentence that begins with the word however. It would be wrong to assume that the dividing line between issues of jurisdiction and the merits is drawn at the same point before an investor state tribunal as it is before an English court applying an English statute. And the learned judge had made the same point in his judgment in Diag Human, which he sets out in the next paragraph, paragraph 28. Now, the learned judge moved on to consider another case in which Section 67 was an issue. You see this at paragraph 33. The case was Tatneft versus Ukraine. In that case, Mr. Justice Butcher was asked to consider, in the context of a plea of state immunity to enforcement, whether Ukraine had agreed to arbitrate a dispute over the breach of a fair and equitable treatment standard that had been found to have been imported into the treaty by way of a most favoured nation clause. And Ukraine had argued that because the fair and equitable treatment standard did not appear in the treaty and was imported only by way of the most favoured nation clause, so a breach of such an imported standard did not come within the scope of the agreement to arbitrate. Let us pick up the learned judge's description of the Tatneft judgment in his paragraph 33 Roman I. You see there that he quotes a paragraph from Mr. Justice Butcher's decision, that's paragraph 51 of the Tatneft decision. The logic of Ukraine's case here would seem to be that any dispute as to the interpretation of the protections afforded by the terms of the bid is jurisdictional. In any such case, it could be said that as Ukraine had not on its case agreed to confer a particular protection, then it had not agreed to arbitrate claims alleging a breach of the obligation. I consider that such a result would be contrary not only to the terms of Article 9, but to the broad intention behind bilateral investment treaties. And the final extract from a prior Section 67 case that I'll take you to addresses the point that we were just discussing. It appears at paragraph 35 of the judgment, and it pertains to the Republic of Korea's failed Section 67 challenge in relation to the case of Korea versus Dayani. Korea had argued in that case, my lords, my lady, that a matter of state attribution that it had argued unsuccessfully in the underlying arbitration was a matter of jurisdiction, and so amongst other challenges launched a Section 67 challenge on the basis that the finding that the act of a state entity in question there was attributable to Korea was a matter of jurisdiction. Mr. Justice Butcher said that it wasn't, and he said that it wasn't in terms that we say are instructive, and I'd ask you to focus your attention on Roman 4 of his paragraph 35, in which again he quotes from the judgment of Mr. Justice Butcher, "I would regard it as both surprising and highly inconvenient if issues as to attribution were regarded as jurisdictional. Such issues are commonplace. In investment arbitration are often both factually and legally complicated. If they were matters which were automatically jurisdictional, it would involve the municipal courts of the seat resolving issues which are integral to the merits of many claims under bilateral investment treaties." there we see the learned judge considering the interpretation of the treaty pursuant to the Vienna Convention, but through the particular prism of the implications of Section 67 and the opportunity it offers for a de novo review.
Well, obviously we're not being taken to the underlying case, but I don't recall that it's really considering the interpretation, a disputed interpretation of the treaty, more the characterisation of what the terms of the treaty provide.
Yeah. I might add one thing to what you've just said, my lady, and that is that although that was under a different treaty, it was a bilateral investment treaty, there was a discussion of what dispute meant under international law. And it might be worth us just looking at that, because when we come to the terms of Article 1116 of our treaty, we say the fact that in order to come within its scope, a claim must be made of a breach of the obligations in Section A, does draw parallels with the debate and the judgment of Mr Justice Butcher on what the meaning of dispute is.
I had also picked that up, but I'm not sure, still not sure it really answers my question about the nature of the dispute in this case. But take your own course in terms of when you want to look at that.
I think we don't. I think that I can see, my lady, you're very familiar with the relevant passage in Diani, so I don't think I will take us to it. If you have a particular...
Not all of us are
Exactly.
equally.
My lords, if you'd like to, we can turn to it. So this is at tab 57, which will be in your volume 2. And let's begin perhaps with the learned judge's considerations of Article 31 and 32 of the Vienna Convention. If I could ask you to turn to page 4450 and paragraph 31. And you'll see there that the learned judge describes those articles as making clear that the basic rule of interpretation is textual. You'll see just on the facing page, paragraph 27, the agreement to arbitrate under that investment treaty. That was the Iranian-Korean treaty. Any legal dispute arising directly out of an investment between an investor and the other contracting party. And then I'd ask you to turn your attention to paragraph 87. This is where the learned judge is considering whether or not a dispute as to attribution comes within the terms of that agreement to arbitrate. And I'd ask you to focus on a sentence that begins in the middle of paragraph 87. The term dispute in international law has the meaning of a disagreement on a point of law or fact, a conflict of legal views, or of interest between two persons. So clearly the court there was being driven by the breadth of the arbitration clause, the reference to dispute, and also the breadth of the meaning of dispute as a matter of international law. And we say that that is relevant when you come to the terms of Article 1116, which talks of a claimant making a claim of a breach of the obligations in Section A.
Yes, but that's not really the issue here, is it? The question is whether or not, before you even get to that, this is all conditional upon 11.1.
Yeah, we clearly, my lord, the terms of our arbitration agreement is not on all fours with the arbitration agreement in this treaty. And we will come to the terms of this treaty, but we do think it is useful for this court to see the breadth of the international law term, meaning of the term dispute. And I hope that I'll come to explain why that is highly relevant, actually, to determining the relationship between 11.16 in our treaty and 11.1.1. This, I accept, my lords, my lady, is, I hope, helpful background, but background nonetheless.
Yes.
If we go back to Mr. Justice Foxton's judgment at paragraph 37, so this is Core Bundle, tab 6, page 85, 84, 85, we'll see in his paragraph 37 that he sets out the principles, 5 principles, to be drawn from his survey of the existing Section 67 case law. And we submit that they are a faithful reduction of the principles that emerge from the Section 67 case law. Now, my learned friend, even though there was notably no discussion of the Section 67 case law in his skeleton before the learned judge, as there was none in his appeal skeleton before you, submit that the principles recorded here are legally flawed. And so we come to the first category of so-called error, the so-called error of approach, which are in truth, my lords, my lady, we submit a complaint about the existing case law on Section 67, so far as the approach is concerned. I'm going to offer you one example for now, because I'm keen to move quickly to the judge's interpretation of the treaty, which is at the heart of the debate before you, in concreto, rather than so-called errors of approach. That error that I'm going to focus on, just by way of example, is error 4, which is described at paragraph 26 of my learned friend's skeleton. That's Core Bundle, tab 3, page 24. You see it at the bottom of that page, where the appellant criticises the learned judge for stating that issues that involve the supervisory court determining issues that are integral to the merits are less likely to be jurisdictional in the Section 30 sense. Now, whatever you think of that principle, my lords, my lady, as we've just seen, it comes directly from the pre-existing Section 67 authority. Cases that were not appealed, Tatneft, Dayani, in particular, Mr. Justice Butcher's decision in the Dayani case. So we're going to turn, having looked lightly at the so-called errors of approach, to turn to the learned judge's interpretation of the Chorus Free Trade Agreement itself. It has, of course, been common ground, and we've discussed it already, that this is governed in its interpretation by the Vienna Convention on the Law of Treaties 1969, and the learned judge was alive to that, of course, and set the relevant provisions of the Vienna Convention out in his judgment. You see them at paragraphs 18 and 19 of his judgment. That's core bundle tab 6, page 77. 76 in the hard copy, 77 in the opus copy. In paragraph 18, he sets out the terms of Article 31, the general rule of interpretation, and at paragraph 19, he sets out the terms of Article 32. And as we consider the terms of those articles, we think it may be helpful to recall the description of the approach to interpretation that they prescribe that the English courts have taken before. You saw Mr Justice Butcher's reference to the rule of interpretation being textual, not teleological, in the Diani case. And let me give you another reference in the Tatnef case. You can go there if you like, but I can give you the reference. Paragraph 39 of Tatnef. That's Authorities Bundle, tab 56, page 4419, where he offers the same view as to the primacy of the textual approach to interpretation. And similar statements have been made more recently, including by the Supreme Court in the Al-Malki versus Reyes case. And we can go there in due course when it is perhaps a little more relevant to my submissions. So taking those tenets into account, I'm going to focus now on the text of the treaty and the specific question that was before the learned judge and that is before you, which is whether the requirements in 11.1.1 are matters that condition the consent to arbitrate and therefore relate to substantive jurisdiction of the tribunal within section 67. And our submission, let me summarize it first, members of the court, my lords and my ladies, before I take you through it, can be boiled down to three propositions. Point one, the agreement to submit to arbitration is found in section B of chapter 11, in particular articles 11.16 and 11.17 of the treaty. Point two, when one focuses on the ordinary meaning of the terms of the agreement to submit to arbitration there, one can ascertain that they extend the parties' consent to arbitrate to investment disputes that involve a claim that the respondent state has breached its obligations inter alia under section A. And we submit that a claim that an obligation under section A has been breached necessarily involves a claim that the obligations under section A apply. Put another way, the claim that the obligations under section A apply is part and parcel of a claim that they have been breached, that the parties have agreed to arbitrate.
What obligation under section A is referred to?
Any of the obligations of substance, my lord. We'll look at section A in some detail, but it includes the whole range of typical investor protections, the minimum standard of treatment, national treatment, non-discrimination, and the others. And then there are a series of provisions in section A that also deal with when those substantive obligations apply. And we say that a claim that one of those obligations has been breached, for example, in this case, there was a finding on the merits of breach of the minimum standard of treatment, necessarily entails a claim that those obligations in section A apply, and therefore comes within the agreement to submit claims of a breach of Section A to arbitration.
Well, it just begs the question, doesn't it? It just simply begs the question that we're debating.
It is a reading of the treaty, my lord, that makes sense. It is a reading of the treaty that recognises that 1116 stands and works alone. It is a reading of the treaty that makes sense of the language in 1111, that this chapter applies to measures adopted or maintained by a party that relate to an investment.
If I've understood your argument correctly, it reduces the jurisdictional criteria that actually exist on your argument in 1116 are very limited.
But they are, my lady...
Because if I've understood you correctly, the question, and no doubt we'll get to the detail, but for example, the question whether the claimant in fact has an investment in the other party's state is at most sort of encapsulated within the subject matter of the claim in the way that you've just described. In other words, all that 1116 requires as a jurisdictional matter is an investment dispute, not defined, but investment is very broadly defined, and I don't think with a jurisdictional limitation, or at least doesn't say it has to be in the other state. I may be wrong about that. But if I'm right, investment dispute is extremely broad. You just have to consider that there's an investment dispute, and then have a claim, for example, that there's been a breach of an obligation in Section A. What other jurisdictional requirements are there on your case?
Well, the typical jurisdictional debates that take place in investment treaty arbitration pertain to exactly those issues. First of all, ratione personae, do you have a qualifying claimant? That is part and parcel of the regime in 1116 through the definition of claimant, disputing parties.
Yes.
And that is something, my lady, that is regularly, vigorously debated in jurisdictional battles in investment treaty arbitration. Does someone qualify as a protected investor? That's one. The second, and this takes us to the definition of investment, which you noted is capacious.
Yes.
It is a very typical definition of investment that one sees in investment treaties. But there are regularly vigorous debates about, and this is the ratione materiae debate, there are regularly vigorous debates about whether the investment in question is such a protected investment. For example, in Diani, the issue was whether the participation in the payment of an upfront payment to a contract to obtain a shareholding in a Korean company was a protected investment.
Are you saying the question of whether there is an investment is jurisdictional? I mean, by the way, I've just checked the definition of investment doesn't have a jurisdictional limitation, as I understand it. It's a very broad definition. Are you saying that when you read 1116, which says, in the event that a disputing party considers that an investment dispute cannot be settled, can you explain how beyond the claimant concept there is a jurisdictional restriction by reference to showing you've got the right sort of investment?
Indeed, my lady, and this is an issue that arises quite regularly on the basis of very similarly capacious definitions of investment. And the question that arises is the asset or the transfer of funds in question an investment? And the kinds of debates that have been had, for example, pertain to the participation in a tender process, unsuccessfully treated unfairly by a failing tender party. Question has arisen, is that an investment that is protected by the treaty? There is undoubtedly jurisdictional fibre to the question of whether one has an investment that is protected by the chapter. And I don't think that there is any debate between the parties that one of the jurisdictional issues that arises, typically in investment treaty arbitration, I'll be corrected if I'm wrong about this, typically in investment treaty arbitration is whether the funds that you have made available, the value that you have lost, qualifies as an investment. Another debate that takes place in the international case law, for example, is the permanency or duration of the transfer of funds. Is it sufficient to qualify as a matter of international law as a protected investment, or was it a one-off purchase? That debate has raged in investment treaty arbitration jurisprudence. It is a ratione materiae debate, and it arises from the interpretation of definitions of investment, very much like the one that you see here in section C.
Yeah. I think I might just to point out, I think I might be able to answer my own question by reference to the definition of claimant, because that is defined on page 285 as an investor of a party, and when you go to that definition, it does talk about investment in the territory of the other state. So if that's right, everything works through the definition of claimant. That's the extent of the jurisdiction.
You can still have a debate about whether what the claimant has is an investment within the definition as well.
Of course, yes.
And the third point I was going to make of my 3 points of the overview of our position on the reading of the treaty, and then we'll go through the terms in some detail, is that there is no basis to read into the consent to submit to arbitration the restrictions in 11.1.1 at the beginning of section A, because they define the scope of the substantive protections, not the scope of the consent to arbitrate. One provision you weren't taken to, my lords and my lady, yesterday is 11.18, which appears in section B, which is entitled Conditions to the Consent to Arbitrate, and makes no reference whatever to 11.1.1. Now, I want to come and focus on the terms of 11.16 in some detail, and this may be the right time to do so. Let's turn to it. It's at Core Bundle, tab 9, begins at page 273 in the Opus. That's Core Bundle, tab 9, page 273 in Opus, 272 in our hard copies. We see the title at the bottom of the page. It makes clear that this is the section that pertains to the process for settling disputes arising from the substantive protections delineated in section A. It comprises 12 sub-articles, my lords, my lady. I don't think there can be any doubt that it is, on its face, extensive. And it begins at 11.15, which begins with the requirement for the parties to attempt a resolution of any investment dispute by consultation and negotiation in the first instance. And as was noted yesterday, that is not a defined term. Therefore, it must be given its ordinary meaning in context. We do have a definition of investment, which is capacious, and so the ordinary meaning of that term must be embedded within the definition of investment to mean a dispute relating to that investment. And that is not an unusual formulation to see in investment treaties. I just remind you of the terms, the broad terms of the agreement to arbitrate in the Dayani case, which was broadly in similar terms. The section B moves on then to 1116 and 1117, the submission of a claim to arbitration and the consent to such submission. We'll look at these in some detail, and we'll begin with 1116. In the event that a disputing party, that is a defined term as you know, it includes a claimant, which is a national of a party to the contract, considers that an investment dispute cannot be settled by consultation, the claimant may submit a claim that the respondent has breached, inter alia an obligation under Section A. Of course, it mustn't establish that there has been a breach, it simply must make a claim that there has been a breach. You wouldn't expect to have to prevail on your claim to establish jurisdiction. And to understand this fully, of course, we have to read it with the definitions in Section C, which we've already spent some time to, but if it's useful to do it in order, let's do it together again. Page 285 of the bundle. Disputing parties means the claimant and the respondent. Claimant means an investor of a party that is a party to an investment dispute. Again, undefined, but we do have the definition of investment. We'll come to consider the definitions of investment agreement and investment authorization in due course. But with those definitions in mind, and focusing on the ordinary meaning of those terms, we submit that if you have an investor with an investment who has an investment dispute that involves a claim of breach of an obligation in Section A, then the parties consented to that claim being submitted to arbitration. And I note in particular the clear distinction in 1116 between obligations under Section A and arbitration under Section B. And to repeat a submission I made earlier, the word
Sorry, can you just repeat? What are you saying there's a clear distinction between?
Yes. If we look at 1116(1)(a), my lady, the claimant on its behalf may submit to arbitration under this section, that's Section B,
Yes.
a claim that the respondent has breached an obligation under Section A. So a recognition and a respect for that delineation. And to repeat the submission I made earlier, we say that a claim of breach of an obligation under Section A must necessarily involve a claim that the obligations in Section A apply. That was our submission before the learned judge.
It can be on the assumption that they apply. The claim is that they've been breached. Again, it just begs the question, it seems to me.
My lord, I may not be following that.
Well,
apologies.
What 1116 provides, as you say, is that the claim that the respondent has breached an obligation under Section A. It may be, as you say, that one of the issues that then arises is there an obligation under Section A, or it may be that the assumption or condition is that there is an obligation under Section A. That is the question. It doesn't seem to me that it answers it in either way.
We would submit respectfully, my lord, that in order to determine whether there has been a breach, then you must walk through that doorway and indeed ask and answer that very question. That is part and parcel of a determination of whether there has been a breach of section of an obligation.
Not if the precondition of all this applying is that there is a measure.
But the question of whether there has been a measure is surely relevant to the claim of whether there has been a breach of Section A.
Well, of course it is. And
so, in what way would it not be part of the scope of the agreement to submit that question to arbitration?
Because the whole thing only arises if we're dealing with measures. That's the argument against you. That's what we're addressing. It doesn't seem to me that that language answers the question one way or another. That we have to look at it all together.
I would certainly agree that we have to look at it all together. My modest submission is that it is difficult to see how, in determining whether there has been a breach of an obligation in Section A, you don't have to ask the question, do those obligations apply? And if that is right, then that necessarily means that the question of application of the obligations in Section A is part and parcel of what has been submitted to arbitration.
But you could say exactly the same thing about investment. Don't you have to decide whether or not there's an investment? But you accept that that is a jurisdictional question.
We do accept that that is a jurisdictional question, but that is not part of the question of whether there has been a claim of a breach of an obligation under Section A. That is part of the question of whether you have a disputing party, a claimant that has an investment dispute. Those certainly are jurisdictional questions that you must ask and answer before you come to the claim of a breach of Section A. Now, the submission I just made, my lords and my lady, to you is exactly the submission that was made to Mr Justice Foxton. Let's look at his acceptance of it. So at tab 6 of the bundle, the core bundle, it's paragraph 45, 6. And if I invite you to focus on the final sentence of that subparagraph 6, of the final two sentences, you'll see reflected there the submission that you just heard. Now, attention was given at trial to the other limbs of Article 1116, which refer not to claims of breach of the obligations under Section A, but claims of breach of an investment authorization or an investment agreement. And those alternative sources, as my lords, my lady, you know by now, do not appear in the NAFTA, and so tribunals applying the NAFTA have had no reason to grapple with them or their implications. And these alternative sources created anomalies, so far as the learned judge was concerned, in reading Article 1111 as the appellant submits to condition the consent to arbitrate. And we'll come back to those anomalies, but before we do, let's turn to Section A. This is, and in particular I'm going to focus now on the language that the appellants focus on. The very first sentence of 11.1.1, this chapter applies to measures adopted or maintained by a party relating to. And it has been our submission, as you know, that this language can be understood to define the scope of the substantive protections in Chapter 11. And that was the issue that was extensively debated before the learned judge. And his decision on that debate begins at paragraph 41 of his judgment, which I think it would be worth us looking at. So that's Core Bundle, tab 6, page 86, in the hard copy version, 87 in the electronic version. And as we come to look at the learned judge's reasoning on this issue, it seemed to be suggested yesterday that the learned judge had reached the conclusion that the scope and coverage provision was purely descriptive, with no other effect. That was my understanding of the submission that was being made yesterday, that was the learned judge's characterization of that language. If my understanding is correct, we respectfully submit that that is not an accurate characterization of the debate before the learned judge or his interpretation. Our submission was that 11.1.1 defined the scope of the substantive provisions.
I think that's how we understood the judge to have concluded.
Indeed, and that's, I think, quite clear from 41, but there was a discussion yesterday of somehow an impression being left that 11.1.1 was relegated to a purely descriptive function. That was not the debate before the learned judge. That certainly isn't our position, and if we read paragraph 41, we can see that that isn't the judge's view.
Well, indeed, you proceeded with both parties proceeded with the arbitration on the basis that you did need to establish there were measures.
Indeed.
Or a measure.
Indeed. As a matter of substance in our case. As
Yes.
a matter of jurisdiction in our
indeed.
friend's case. And we see here in his subparagraph 1 in his explanations for why he preferred our view that the concept of scope and coverage still makes sense if they are understood in defining the scope of the substantive protections in Chapter 11. And at paragraphs Roman 2 and Roman 3, he notes that the Free Trade Treaty comprises a series of distinct chapters with different subject matters. Many of them have a scope and coverage clause at or near the beginning of the chapter. The principal role appears to be to differentiate the different subject matters of the separate chapters, but that Chapter 11 is the only one in which the scope and coverage clause appears under a particular section heading, namely Section A, and it's the only chapter with such a clear delineation between substantive protections in Section A and procedural provisions in Section B. And at subparagraph 4, if we read on, at the bottom of the page, he observes that the suggestion that the scope and coverage section at the start of a chapter is intended to condition every other provision in the chapter does not sit easily with the way in which scope and coverage provisions apply in other chapters. He proceeds to give 4 examples. You were taken to one yesterday. Let me take you to a couple more. The first is to Chapter 12, the very next chapter in the Free Trade Agreement. We go to Core Bundle, tab 9, page 298 of the hard copy bundle, 299 of the Opus electronic bundle, we see Chapter 12, Cross-Border Trade and Services. And we see in Article 12.1 a scope and coverage provision that also begins with the words, "This chapter applies to measures." And keeping that language in mind, let's turn to Article 12.5, that's at page 300 of the hard copy bundle, 301 of the electronic bundle, a provision headed Local Presence. This places an obligation on both states not to require a service supplier of the other party to maintain a representative office in its territory. And as the learned judge held, it would not seem a natural reading of Article 12.5 that a state could impose such a requirement for a representative office in the territory unless it could be shown that the decision to do so would affect cross-border trade in services. And so the scope provision in Chapter 12, he found, could not sensibly be read as a provision that conditions all other provisions in the chapter, this even though the provision begins with the words, "this chapter." I might take you to just one other example that he offered, and this is in relation to Chapter 14. If we turn to page 356 in the hard copy bundle, 357 in the Opus electronic bundle, we see that Chapter 14 pertains to telecommunications. And we see it begins with a familiar provision. This chapter applies to measures. And with that in mind, let's turn to an example that the learned judge picked out, Article 14.9 on page 361 of the hard copy bundle. Sorry, that's wrong. Page 364 of the hard copy bundle. Resolution of telecommunications disputes. And this provides a means of resolving telecommunications disputes by setting out certain recourse available to enterprises and suppliers, including an opportunity at the end of the provision for judicial review. And with that in mind, it's interesting to take a look at the learned judge's observations about what it would mean if one read 14.1 as conditioning that access to recourse in 14.19. And that's paragraph 41.5 of his judgment. See it on page 87 of the hard copy bundle, 88 of the Opus electronic bundle. And let me focus just on the last two sentences, having set out the terms of Article 14.1 and 14.19. The learned judge goes on to say, "I accept that Article 14.19 is different in character to Article 11.16 because it does not involve an offer by a state to submit to the jurisdiction of a private dispute resolution tribunal. However, it seems unlikely that the right to access such bodies is subject to the jurisdictional bar of showing that there has been a measure affecting trade. Ordinarily, that would be one of the very disputes which the relevant regulatory or judicial bodies would have to decide." And I submit, my lords, my lady, that it is fair to say that the appellant has no real answer to the consequential anomalies arising from its purported interpretation so far as other chapters are concerned. And to make good on that, let's just focus on the relevant part of my learned friend's skeleton. It's at paragraph 34.1 of his skeleton, core bundle, tab 3, page 29. If you take a moment, my lords, my lady, to review the response to the learned judge's consideration of the provisions of other chapters, it seems to us that the main response appears to be that the proper interpretation of scope and coverage provisions in other chapters may involve them having a different meaning. We submit that that would be a surprising outcome, that the same words used in the same treaty again and again would have different meanings. And that is relevant to your consideration of the ordinary meaning of the terms in context, as Article 31.1 of the Vienna Convention requires.
So, just with Chapter 14, of course, as I understand your position under Chapter 11, you say 11.1 does qualify Section A, broadly, as the judge says. But you can't make quite the equivalent argument in relation to Chapter 14, can you? I mean, there's on a quick look, there's a number of different sections there. And it might be that one article, Article 14.19, doesn't fit very well with Article 14.1, but it's not the case that you're construing, as I would see it, that you would be construing 14.1 as applying to specific provisions and not to others, whereas in this case you're saying it does have real bite on the obligations in Section A.
Yes, the placement of the language in 14.1 is not exactly in the same place, because in our chapter it appears within Section A, whereas in this chapter it appears above Section A. And so the parallels are certainly not perfect, but the tension that the learned judge was referring to nevertheless remains if the language is to be given the meaning that the appellant argues for in Chapter 11.
Well, it may be that, another approach would be to say that because of provisions like 14.19, you can't perhaps interpret the scope and coverage provision in 14.1 as strictly as you might otherwise do. In other words, something within 14.19 must be regarded as potentially affecting trade, for example. But as I understand it, under Chapter 11, both parties agree that 11.1 has real bite, real effect. If there isn't a measure, then you wouldn't have succeeded before the arbitral tribunal. The dispute is a different one, as in which provisions, which parts of Chapter 11 does 11.1 qualify. So I'm not quite convinced that the other chapters do help as much as you say they should.
I'm pointing out that the learned judge considered that this was of interest. I don't think he considered it determinative. The challenge for my learned friend is to offer a linguistic answer to the proposition that the same language is used differently in different chapters.
reach a convenient point to break for 5 minutes, let's do that.
My lord, this is a convenient moment. Thank you.
Hey, good.
Yes.
Yes.
My lord, my lady, I was going to spend a little bit more time now on the content of Section A of Chapter 11, kinds of protections that we see ranged within it. So let's turn to Section A, page 264, core bundle, tab 9. Now, the learned judge observed that this section was principally concerned with the substantive protections afforded by the treaty. And the word he used was principally, not exclusively. That's at paragraph 40 of his judgment. And he's undoubtedly right about that. And to see that, if we cast our eye through Articles 11.3, national treatment, 11.4, most favoured nation treatment, 11.5, minimum standard of treatment, all the way through, my lords, my lady, to 11.9, we see the usual combination of substantive protections that one sees ranged in investment treaties around the world. And the section also contains provisions that deal with the scope of application of those substantive protections, i.e. when they apply and when they don't. Let me give you one example of that. Article 11.10, bodies and environmental protection. Nothing in this chapter shall be construed to prevent a party from adopting, etc., etc., in relation to environmental concerns. That's the scope of the substantive protection. Now, the appellant has made the point that Section A is not limited to substantive protections, but the language that the learned judge used is that Section A didn't only concern substantive protections, but that it principally concerns substantive protections. That's paragraph 40 of his judgment. And the appellant does not contest, so far as we understand it, that all of the substantive protections appear in Section A.
Which ones are in issue in this case?
The claim in the underlying arbitration was made for two breaches, my lord. The first was the breach of the minimum standard of treatment. That claim was successful. That is what has led to the damages award against the Republic of Korea. The second was a claim of discrimination. And that claim was not successful on the basis that Elliott was one of a number of shareholders, minority shareholders, who suffered from the governmental corruption that resulted in the breach of the minimum standard of treatment claim.
So in the discriminate, where's that in the treaty?
The national treatment claim, 11.3, and the most favoured nation treatment claim 11.4 are the two substantive obligations that go to the discrimination claim that was not successful, and 11.5 is the minimum standard of treatment claim.
Thank you.
Now, a submission was made yesterday that there are other provisions in Section A that are similarly jurisdictional to Article 11.1.1 on the appellant's case, and you may remember that you were taken to the denial of benefits provision, which we should look at together. That's at 11.11. And the submission was made to you that this denial of benefits provision was necessarily and obviously jurisdictional, thereby muddying the dividing line between Sections A and Sections B. Now, the appellant referred to some investment treaty awards in which the state's invocation of the denial of benefits clauses has been characterised as jurisdictional, and he took you to some yesterday. And there are 2 points, my lady, my lords, in response. First, we've already discussed why the jurisprudence of investment treaty tribunals is of limited assistance to this court. There is no practical consequence for many investment treaty tribunals as to how they characterise a preliminary objection that one way or the other will have to be heard. Under Section 67, a characterisation, in the words of the learned judge, is everything. And the second submission I'd make is that a broader view of the jurisprudence of investment treaty tribunals indicates that denial of benefits clauses are certainly not always treated as jurisdictional objections. It depends, as always, on the interpretation of the treaty. In the Energy Charter Treaty, for example, the denial of benefits clause is contained, rather like in our treaty, in a different section of the treaty from the consent to arbitrate. And arbitral tribunals faced with a denial of benefits objection have, as a result, treated it not as jurisdictional, but as an objection to admissibility. I can offer 2 examples of that, my lords, my lady. Neither of them, I'm afraid, are in the bundle. And so I'm in your hands as to whether I simply give you the references or whether you would allow us to hand you copies now, and I can show you how I make good on that point.
Have the other side been given notice that you're going to rely on these cases?
They have not, my lord. My lord, if you're uncomfortable, I can simply leave you with the proposition.
My lord, if it is of assistance, we have no objection whatsoever to these being put in, although we haven't been shown them before, as long as my learned friend takes you to the wording of the relevant provision in the Energy Charter Treaty, which is materially different.
All right. Well, on that basis, hand them in, and
Very well.
we'll see whether they're of any assistance.
While they're being handed up, let me give you the name of the 2 cases. They're well-known investment treaty awards. One is the case of Plama versus Bulgaria. The other is Hully versus Russia. It's one of the UCOS cases, one of the cases that came out of the UCOS dispute. I'll begin, my lords, my lady, with the Palmer judgment. I won't belabor this point. I'll ask you to turn to paragraph 143 of the judgment. That records the terms of the denial of benefits provision that appears in the Energy Charter Treaty. In the first sentence of that paragraph 143, it explains that Article 17 is contained in Part 3 of the Energy Charter Treaty. That is the same part containing the Energy Charter Treaty's substantive protections for investors, but a different part from Part 5, which contains the provisions for dispute resolution. And then if we can turn to paragraph 146, under the section entitled Article 7 as a jurisdictional issue, that was the question before the tribunal. And at paragraph 147, we see that the tribunal explained that this is a question of treaty interpretation, Article 31 of the Vienna Convention. And in interpreting the treaty, it finds that the denial of benefits does not extend to Article 26 in Part 5, which contained the offer to arbitrate. That is, that Article 17 was not a limitation on the offer to arbitrate. It was an objection of a different type.
But as you've shown us in paragraph 143, the express wording refers to right to deny the advantages of this part, i.e. Part 3.
Indeed.
Whereas the dispute settlement provision is in Part 5.
Indeed. And our point, my lady, is that the proposition that was put to you yesterday is that denial of benefits clauses are necessarily jurisdictional. And our response is it depends on your interpretation of the treaty. They are not of nature jurisdictional. They are jurisdictional if they are considered such on a proper interpretation of the treaty. And the same question arises here. In our case, they appear in Section A rather than in Section B. And so the proposition that they are necessarily of their nature jurisdictional is not a correct one.
Okay, so well, you obviously don't need to assert this, but would you be saying that the reference in 1111 to may deny the benefits of this chapter may in fact be limited to the section rather than to Section A rather than Section B?
We would say that the words this chapter would be understood in the same way as the words this chapter in 1111. In other words, there's nothing to be gained from the nature of a denial of benefits clause to determine whether Section A is trespassing into matters of jurisdiction. Again, it depends on your interpretation of the treaty.
Well, is the right to submit a claim to arbitration a benefit?
The question of whether it is a benefit and therefore that this conditions the request to the consent to arbitrate, my lord, is exactly the question that this tribunal decided in the negative. That the benefits that this was dealing with were the substantive benefits in a separate part of the Energy Charter Treaty. And I'm not suggesting that you need to interpret the free trade agreement in the same way as the Energy Charter Treaty. I'm simply proposing that this confirms that there is nothing of nature of a denial of benefits clause that answers the question that is before you, which is how to understand the protections in Section A. I can make the same point in the same way in relation to the Hulley Award, if you'd like me to. It's the same proposition, but if not, I may move on, my lords and my lady, as you prefer.
For my part, I would be content if you gave me the paragraphs.
Very well. And so in Hulley, the paragraphs I'd ask you to look at would be paragraph 439, which is a section entitled, "Are the claims barred by the denial of benefits provision of the ECT?" And paragraph 440 that addresses this very question. Is the question one of jurisdiction or some other form of objection? You were also taken to the subrogation provision in our section A, which is Article 11.14.
Yes.
And the short point here, my lords and my lady, is that the question of whether it is a condition to the consent to arbitrate or a provision that indicates that political risk insurers can become beneficiaries of the substantive protections in the treaty is again a question of treaty interpretation. There is no clear arbitral practice that indicates that this is necessarily jurisdictional in nature, and I would note that none was pointed to yesterday in the submissions made by my learned friend.
Can I make sure I've understood this? If 1114 were limited to, for example, Section A or substantive provisions, how could the subrogee be able to invoke the arbitration?
The question that this gives the question that this gives rise to is whether they would need to go through the claimant, the insured, to bring a claim where they are now the beneficiaries of the substantive protections. And our submission, my lady, is simply that that question has simply not benefited from arbitral jurisprudence as to whether it should be characterized as jurisdictional or some other form of objection. There was a presumption made to you yesterday that of course it must be jurisdictional, and my simple submission on this point is there is no authority for that point.
I was making a rather more basic point. 1114.1 says the investor shall be entitled to the same rights that the investor would have possessed under this chapter, but for the subrogation, which makes the assumption, among other things, that the investor no longer has those rights. I'm asking whether the entity subrogated, whether the natural interpretation is that the entity subrogated would have all the rights under the chapter, which would include potentially the right to arbitrate.
And my response, my lady, is simply that that isn't a necessary reading of 1114. That another reading of it is that the claim is still brought by the claimant party and national party of the investor, even if the party in interest is the insurer.
You mean they bring the claim in the name of the claimant?
Indeed. As a subrogate.
But the final words are, the investor shall be precluded from pursuing such rights to the extent of the subrogation.
Were it otherwise, it's very difficult to see how the terms of 1116 are fulfilled, because it is not a claimant. It doesn't come within the definition of the claimant.
Well,
it does because of 1114.
1114 has that effect.
Now, the proposition that was put to you yesterday is that this is necessarily jurisdictional. My only response is there are two ways to read that. It doesn't really tell you the way in which you should read 11.1.1. And there's no authority suggesting otherwise. So far as we're aware, there's no claim brought by a subrogee directly under an investment treaty asserting jurisdiction under a clause such as this. I would also note, my lady, my lords, that the kinds of issues that would arise if one brought a claim directly as the subrogee under 11.14 would simply require you to determine whether you are an insurer, one of the two that are named, and whether you have made a payment. Quite different from the kinds of issues that arise for determination under 11.1.1.
Yes, but we're looking at this for a different purpose. We're trying to get guidance, really, on whether references to this chapter in section A are to the whole of the chapter rather than this section. And the relevance of this provision is, at least at first sight, it would seem to make more sense if this chapter meant this chapter.
Yeah.
I'm not really, that's the reason I raised the point.
Indeed.
Rather than anything more than that.
Understood. And for as far as it goes, what it doesn't tell you is whether 11.1.1 is jurisdictional. Even if you were to find that this has more jurisdictional fibre than 11.1.1, it doesn't answer the question in relation to 11.1.1. I'm going to move on to the question of the anomalies, my lords, my lady, that the learned judge identified in reading 11.1.1 as conditioning 11.16, given the differences that exist in 11.16 in comparison to the equivalent provision in the NAFTA. And those anomalies arise because of the alternatives that you see in 11.16 A, 1b and C, that, as you know by now, do not feature in the NAFTA. If we turn to those, just to focus on them again, it's page 273 in the bundle. You've understood, I think, that B and C are simply nowhere to be found in the NAFTA. This gives rise to the anomalies that we see the judge identify in his judgment at page 90 of the bundle, 89 of the bundle, paragraph 46.3, which we might turn to. You were taken to this section in the learned judge's judgment by my learned friend yesterday. He sets out various anomalies that he did not consider sat well with reading 11.1.1 as a superimposed condition to these aspects of the agreement to submit to arbitration. And I'd like to develop the anomalies a little further. Let me begin, and we're focusing now on the requirements of 11.1.1 with the three different elements of it: party, measure, related to. And let's explore how the superimposition of those concepts on a claim for breach of an investment authorization or agreement work or don't work. Let me start with the word party and how it is used in 11.1. Find this on page 264 of the bundle, and we'll see that 11.1.3 a measure of a party is stated to extend to beyond central government to regional and local levels of government and authorities. Now, I'd ask you to keep that in mind and now turn to the definition of party that is embedded within the definition of investment agreement. You find this on page 286 of the bundle. We see there agreement between an investor and a national authority of a party, and we'll see a footnote, footnote 15, which further details what is meant by national authority and extends only to the central government level. Inconsistency, we submit. Let's turn to the related to element of 11.1.1. Now, on the appellant's case in the underlying arbitration and on the merits before at first instance, although they weren't heard, the term relating to required, according to the appellant, a legally significant connection between the conduct complained of and the investment. I'll give you a reference for that. It's the High Court skeleton at paragraph 75, supplemental bundle, tab 5, page 395. Now, in the event, the arbitral tribunal reached a broader interpretation, finding that the requirement of relating to is satisfied if it was reasonably foreseeable at the time that the measure in question was adopted or maintained, that the claimant's investment would be adversely affected by the measures. You'll find that in the award at paragraph 361. That's the supplemental bundle, tab 3, page 149. Now, that debate is not essential here because whichever meaning is adopted, the appellant's suggestion that this is superimposed as an additional requirement to the consent to arbitrate would render this aspect of 11.1.1 redundant in relation to a breach of an investment agreement, because a breach of an investment agreement will necessarily be related to the investment. So there we see redundancy. Particular redundancy if we look at the final paragraph of 11.16, which imposes the related to obligation within 11.16 itself in relation to authorization agreements, so investment agreements or investment authorizations.
Sorry, this is the proviso, is it?
Indeed. Self-contained proviso. I was going to move to the final superimposed requirement of 11.1.1, which is measures, my lords, my lady, unless you'd like me to slow down a little. The appellant's position is that a measure, my lords, my lady, requires some level of formal sovereign act. That was its position in the underlying arbitration unsuccessfully. It's the position it took in its High Court skeleton, paragraph 88, supplemental bundle, tab 5, page 401 for your reference. Now let's try and superimpose that requirement on the terms of the submission to arbitrate in 11.16, that a claim of breach of an investment agreement be submitted to arbitration. As you discussed yesterday, it would result in some breaches of contract being arbitrated under the investment treaty, so long as they constituted sovereign acts, whereas the rest could not. Now that kind of claim splitting on an imprecise criteria, which undoubtedly goes to the merits of the underlying dispute, but which a supervisory jurisdiction would be invited to consider de novo, is, we submit, at the very least, a less likely interpretation of the treaty. And when I say that...
Sorry,
my lord,
to interrupt. I'll see it as you say that the other side use formal sovereign act as the phrase. Measure is a defined term in the
indeed
agreement, and it clearly goes much wider than formal sovereign act, or it seems to me anyway, to be wider than formal sovereign act. But I think the forum splitting point you're about to make is one you'd make anyway. Is that right?
It is, because it draws the line somewhere, although imprecisely, and that somewhere would result inevitably in forum splitting. So far as the debate on measure in the underlying arbitration, I think you won't be surprised to hear that the word including received some airtime before the arbitral tribunal, and we were successful in arguing that it was on its terms not exclusive. The debate in the arbitration, and this is the debate that would become a jurisdictional de novo review, was whether certain governmental instructions coming from the highest office in the land were indeed directions of government that attracted international responsibility, or were mere conversations that did not. That was at the heart of the merits of the underlying arbitration. According to the appellant, that is a matter of consent to arbitrate. You only establish jurisdiction if you establish that the key ingredient in prevailing on the merits of your claim is successful. Now these anomalies...
Can I just ask for help on the definition of investment agreement that you took us to on 286? I'm slightly struggling with how it works. A written agreement between a national authority of a party and a covered investment, or an investment. That anticipates, does it, there could be an agreement between an authority and an investment?
Yes, my lord. It may well be that the investment is ownership of an incorporated entity within the jurisdiction that itself is protected in, which is why I also always trip on the use of investment there, but that is the explanation.
Yes, thank you.
Now these anomalies, my lords, my lady, simply don't arise under the NAFTA. And that difference is relevant when we will come to consider my learned friend's heavy reliance on NAFTA tribunal decisions. Before I leave the terms of Article 11.16, I'm going to move on shortly to consider the reliance that's placed on NAFTA decisions. I did want to draw attention once again to a provision that received very little airtime yesterday, and that is 11.18, conditions and limitations on consent of each party, which again makes no reference to Article 11.11. Here we have a self-contained agreement to submit to arbitration with all the definitions that you need, incorporating all of the classic jurisdictional requisites that are required: ratione personae, ratione materiae, ratione temporis, all dealt with in Section B as you would expect. And if it really were the case that 11.1.1 were expected to be an additional condition to the consent to arbitrate, one might have expected to see it within the terms of 11.18.
But these conditions and limitations are all procedural, aren't they?
Procedural and jurisdictional, my lord.
Well, they may be jurisdictional, but they are matters of procedure, which may give rise to a jurisdictional issue.
They contain the consent to arbitrate. It's the heart of the jurisdiction of the tribunal. 11.17 and 11.16. Consent to arbitrate in 11.17 refers to the submission of a claim, consent to the submission of a claim. That is 11.16 submission. So that is the heart of the consent. And then the regime procedurally, well, before I get to the regime procedurally, and the conditions and limitations on the consent, and then the regime procedurally for how that arbitration, including the provisions of transparency, will unravel.
Well, the substantive consent in 11.17 is to submission of a claim for arbitration under this section, which is 11.16.
Indeed.
And that's the substantive consent, isn't it?
Indeed.
And 11.18 is dealing with timing and form.
Yes, conditions and limitations, including the ratione temporis point, the timing point. And waiver as well, if you look at the very bottom of page 275.
Yeah, those are the formalities which must be complied with in making the claim.
I would not describe matters of ratione temporis materiae and personae as mere formalities, and that you find in 11.16. Yes, you have the formalities. Yes, you have the procedure, but you also have the consent.
Well, it may not matter exactly how one classifies them, but the point is that the substantive jurisdiction, even on your case, is to be found in 11.16 and 11.17.
Indeed. Indeed, that is our submission. We do say that there is some force, though, in recognising that Section B is so all-encompassing. We may describe them as procedural, but they are the procedure associated with the consent to arbitrate. Self-contained is the way I would describe it.
So, but the point I'm just trying to make is, I think your submission is, if it was to be a condition that the subject matter was a measure, then you'd expect to see that in 11.18.
Indeed.
And I'm putting to you that I don't think you would, because that's not what 11.18 is dealing with. You'd expect to see it in 11.16 or 11.17. Probably 11.16. If it's not already there in 11.1. Yes.
My lord. I was going to move on, unless I can help you further with the terms of the treaty.
Can I just ask something?
Of course, my lord.
It may not be relevant, but it just interests me. Article 11.20, which we haven't looked at, has under paragraph 6 provision for objections as to competence, set out in some detail with, we'll say, paragraph 7. So, was that used in this case?
The objections that were raised were heard with the merits. There was no request to bifurcate those objections so that they be heard first. That was available the Republic of Korea, and in fact in the parallel Mason case, you had reference to Mason yesterday, just want to make very clear that you understand it relates to exactly the same corrupt transaction that was the subject of our claim. Mason was another minority shareholder in the Samsung entity that was harmed by the governmental corruption, and so brought a parallel claim. And in the Mason case, Republic of Korea, represented by other counsel, raised their preliminary objections, measures related to party, early, as they were entitled to. In our case, they chose not to, for reasons that we expect were tactical, but the option was available to them in the same way as it was in the Mason case.
Yes. And 6D of 1120 does make it clear that there's no waiver, and it's very favourable to respondents to either take the objection at the start, or you can see how things are going and take it later on.
Indeed, and a tactical option that is available to parties, and different tactics in two parallel cases.
Right. Sorry, you were about to move on from.
My lord, I was. Unless there's any more help I can offer you on the terms of the treaty, I was going to turn to the assistance that can be derived from decisions of other arbitral tribunals.
Yes.
And before I turn to the learned judge's findings in this regard, because again I want to tack close to the judgment that is before you, the first question that arises is, where do such arbitral decisions fit within the interpretive framework provided by Articles 31 and 32 of the Vienna Convention? And if we turn to my learned friend's appeal skeleton, that's Core Bundle tab 3, page 37. Paragraph 54. Long paragraph, but to summarise it, I hope faithfully, he argues their relevance in two ways. He refers to their general persuasive value, and then he goes on to refer to them as being relevant as a supplementary means of interpretation under Article 32. Now, if I may say so, by way of prelude to this part of my submissions, we respectfully submit that a certain lack of discipline is appreciable in the deployment of arbitral awards in this case, almost all of which relate to a different treaty. And the first thing to say is that awards in relation to a different treaty cannot be relevant under Article 31. Article 31 you can put to one side. We can see that in the terms of Article 31. And perhaps let me just very quickly make good on that point by pointing to those terms. They're set out in the learned judge's judgment, paragraph 18, page 77 of the bundle. When you get down to Article 31.3 A and B, we see reference there to subsequent agreement between the parties regarding the interpretation of the treaty. Not a treaty, the treaty. And the same with subsequent practice. Now we'll come to consider those provisions in relation to the diplomatic note in due course, but the first submission I make is that Article 31 is not relevant when we are dealing with awards rendered by arbitral tribunals and not reflecting intent of the party in relation to another treaty. And that's why I expect in my learned friend's skeleton he focused on Article 32, which is whether it is a supplementary means of interpretation. Awards rendered by other tribunals interpreting a different treaty. Now, as we focus on Article 32, let's look at its terms paragraph 19, you see the reference there to circumstances of its conclusion. And so it is our submission, and we'll come to show you in a while how it was also my learned friend's submission before the learned judge, that Article 32 extends to materials that are available as at the date of conclusion of the treaty, rather than subsequent practice. And by reference to the transcript, I'll show you how he made that submission directly to the learned judge. I had something different yesterday. Article 32 might, in very broad terms, be thought of as matrix type evidence, and it's focused temporarily on the period up to circumstances of conclusion makes sense in that context. And as we're focusing on Article 32, I just draw attention to paragraph 20 of the learned judge's judgment, in which he made reference to how this court has understood the role of Article 32 in the case of MSC Mediterranean Shipping v. Stolt. So, with that context for Article 32, let's pick up the learned judge's consideration of the two different ways that my learned friend put his reliance on arbitral awards in other cases. First, for their explanatory power, and second, as a supplementary means of interpretation. He considered both. And let's turn to have a look at his consideration to paragraph 50, from the section from paragraph 53. Here we see the learned judge acknowledge that the appellant relied extensively on decisions reached by NAFTA tribunals, and he accepted that a number of them had treated the equivalent provision of the NAFTA, that's Article 1101, as jurisdictional in nature. He certainly wasn't ignoring the submission. And over the next few paragraphs, we see him describe some of those decisions, beginning with the decisions of the tribunal in the NAFTA claim brought against the United States by the company Methanex. And let's pick up the judgment from paragraph 63. Having set out those decisions, we see him describe why he was not persuaded to adopt the same interpretation of the Korea-US Free Trade Agreement. And in the sub-paragraphs that follow, he offers a number of reasons why. We can look, I'll invite you to quickly scan the reasons at Romans 1, 2 and 3. Effectively is acknowledging that questions of characterization are far less significant in an international arbitration. The tribunal will hear all of the objections, however characterized, when they must be before a court considering a Section 67 judgment, in which the distinction, in his words, is everything. And if we look at the final sub-paragraph, Roman 5, he also noted that when looking at the NAFTA awards, one needed to take account of the differences between the relevant provisions of the NAFTA and in particular Article 1116 of the US Korea Free Trade Agreement, the ones that we've just worked through.
While we're looking at it, the penultimate sentence of that paragraph, I've really not been able to follow.
Of subparagraph 5, my lady.
Yes. The one beginning, nor does the counterparty to Article 1122. I mean, we'll move on if you're not seeking to rely on it, but I couldn't really work that point out.
I may have to return to you on that. I'm not going to be placing any reliance on it, but I'm not able to answer meaningfully immediately. Now, in drawing attention to the textual difference between the NAFTA and the Korea-US Free Trade Agreement, the learned judge did then go on to recognise that in both of the underlying arbitrations in this case, the Elliott case and the Mason case, both of which took place under this treaty, again the tribunals refer to Article 1111 as jurisdictional. But again, he noted that those tribunals were not addressing themselves to the meaning of substantive jurisdiction under the English Act. He noted that there had been no debate before the tribunal as to whether the requirements of 1111 conditioned the consent to arbitrate as opposed to the substantive obligations in the treaty. It was of no moment in the underlying arbitration because the objections would be heard one way or the other. And so he concluded there was therefore no need and no consequence to arguing about how those objections were characterised. And for this reason, he felt that they offered little help to the English court. You see his conclusion to that effect at paragraph 66. And that was the judge's approach to the treatment of the decisions broadly of investment treaty arbitrations for their explanatory power. He then focused on Article 32. And in this context, he inquired whether those NAFTA awards that existed prior to the conclusion of the US-Korea Free Trade Agreement could be considered as part of the circumstances of the treaty's conclusion, such as to qualify as a supplementary means of interpretation. We see the judge then conclude that there were a number of difficulties with that argument, and those difficulties are set out in paragraph 68 of his judgment, prefaced with the observation that these difficulties probably explain why the question was only raised by the observation of the court. And the main difficulty he found was that there was only two decisions that chronologically predated the signature of the Chorus FTA. One was the Methanex decision. The other was a decision involving Bayview and Mexico, not the United States. And he noted that the second of those two was issued on the 19th of June 2007, just days before the signature of the Korea-US treaty, and months after the reported conclusion of the negotiation of that treaty on the 1st of April 2007. And as that award did not include the US, there was simply no information as to whether it had been made available to one of the two signatories to the Korea-US treaty. So he concluded that in truth, he was looking at only one NAFTA decision that predated the parties' negotiation of the Korea-US Free Trade Agreement. And in this context, we note the attempt that was made in my learned friend Skeleton and yesterday to attempt to muddy the water a little bit on chronology by talking about when the treaty came into effect and that it has been the subject of amendment. We submit respectfully that when it may have come into effect is not relevant to this question because there had been no negotiation between signature and it coming into effect. And as none of the subsequent amendments go to this issue, it's not apparent to us how subsequent circumstances can be relevant at all in determining the circumstances at the date of conclusion. And so on this basis, we see the learned judge's conclusion set out at paragraph 68, Roman 4, an interpretation adopted by the one tribunal that had answered this question directly in a dispute involving only one of the states of a different treaty to which Korea was not a party, and on which he said there does not appear to have been argument on this issue, certainly not argument to the same degree as took place before him, cannot realistically be said to establish a meaning generally ascribed to a term by the broader international community. We submit that must be right. And that's what the avalanche of awards that has been thrown at the court really comes down to, my lords, my lady. One decision that predated the signature of a treaty that was meaningfully different in the terms that define the consent to arbitrate. And in this context, we might just look again at Lord Hamlin's remarks in JTI Polska, Supreme Court, you referred to yesterday. I'm going to take you to the judgment, because he too was asking himself about what was and wasn't relevant in the context of Article 32. You'll find it at Authorities Bundle, tab 60, volume 2. And I'm going to ask you to turn to page, well, let's just turn to page 60, tab 60 to begin with. The issue that was before their lordships was the interpretation of a word used in the Convention on the Contract for the International Carriage of Goods. And if we turn to page 4548, relevant paragraphs of Lord Hamlin's opinion appear from paragraph 33. We might pick things up from paragraph 34. It is not possible to be categorical about what documents may properly be regarded as comprising preparatory work or travaux, but they are most likely to be part of the formal record of the Convention rather than expressions of opinion or policy made during the process leading to treaty agreement. Paragraph 35, the documents need to demonstrate the common intention or understanding of the parties. And in that context, paragraph 36 may be the key paragraph. A number of documents sought to be relied on by the appellants reflect opinions of expert bodies. And he goes on to list them. And if we pick things up 6 lines or so from the end of that paragraph, others reflect the intentions of only some of the parties. His conclusion, it is doubtful that documents of this nature can be of any assistance in identifying a common intention or understanding of the parties. Our submission, my lords, my lady, is that a fortiori, that must apply to opinions rendered by arbitral tribunals in relation to another treaty that are not even binding on other arbitral tribunals. There is no system, as you know, of stare decisis. Do not involve both parties, most certainly if they postdate the circumstances of conclusion of our treaty. So we respectfully submit that much of what has been presented to the court by way of a so-called international consensus on the interpretation of a different provision worded differently in the NAFTA does not move the dial one way or the other on the exercise before this court.
May be relevant in infrastructure services and Spain and Zimbabwean border timbers in this court, there were arguments that the interpretation of the Exit Convention, Articles 54, 55, should be affected by what was regarded as the established view of the interpretation of the New York Convention parallel provisions. And this court rejected that suggestion, in part because there's nothing in the Vienna Convention which suggests that material in relation to a different convention is relevant to the interpretation of the current convention.
My Lord, I'm grateful. We will look at it. I wanted to end, and this is my last point, perhaps, my Lord, my Lady, before lunch, by focusing on an interesting paragraph, maybe the segue between the merits before you and the applications. Paragraph 70 of the learned judge's judgment. This is Core Bundle, tab 6, page 98. And I'd invite you just to spend a moment to review paragraph 70 of the judgment, because it is somewhat prophetic, my lords, my lady, in the light of what has followed the learned judge's decision by way of the US diplomatic note of late October of last year. Because, are we there? Will be page 99 for Opus.
Thank you.
Because the learned judge drew attention to the mechanism under the treaty for a joint committee of the signatories to make decisions on the interpretation of a provision of the treaty that would be binding on a tribunal. By the way, not the mechanism that was used to obtain a letter from the US Embassy in Seoul in this case. He goes on to observe in the middle of that paragraph that it is not clear how these provisions would operate in the context of a Section 67 challenge. He then goes on to indicate that while it is far from clear what impact any such interpretation would have after the event in the context of the Section 67 challenge, that interpretation, Article 11.1.1, as jurisdictional, would significantly increase the scope for states to intervene during such proceedings. My lords and my lady, he does not use the words self-help, but I will. And he considered that that also augurs in favour of finding that issues raised under Article 11.1.1 cannot be reopened by an unsuccessful party to be heard de novo by the supervisory court. As I said at the outset, we respectfully submit that this careful and cogent judgment answers all of the grounds of appeal that have been levelled against it. My lords, my lady, if that is a convenient moment, I was going to move on to the applications next. That might be a convenient moment for us to rise.
Yes. Two o'clock.